morning and welcome to the Hawaii State Senate. This is our Monday, February 10th, 2025, 9:30 a.m. Joint committee hearing in conference room 229 at the state capitol between the committees on Public Safety and Military Affairs and Commerce and Consumer Protection. This meeting is being streamed live on YouTube, and in the unlikely event that we experience technical difficulties and need to abruptly end this hearing, please stand by. We will try and hold out until our committee hearing time expires at 11 a.m. Seeing as how this is a deadline week. So we will try and reconvene. Just hang on with us. This is as I just mentioned, this is a 90-minute hearing time slot. And as such, this committee observes a 2-minute testimony time limit. If you've submitted written testimony, it has already been reviewed by this committee. There was a substantial amount of testimony that was submitted for the record. And so in order to make sure that we get all these bills heard and hopefully recommendations made and voted out before the deadline, I would encourage members who have submitted written testimony to stand on that testimony. If you would like to use your time to emphasize or clarify any particular part of your written testimony, that's fine. But we would really ask that you not read verbatim every single word of your written testimony. It's fine to reference the notes because we're trying to move fast and it can get stressful. But please don't read the whole entire thing verbatim. We've already seen it. If you're online, your audio will be muted and your video disabled until it's your turn. If there are technical difficulties, we'll try to come back to you. And on that, I'll yield to the PSM chair for the bill.
Thank you so much, Co-Chair Keoho Kolole. First up on our agenda is SB 696. This is relating to emergency management, appropriates funds for the Office of the Governor in collaboration with the Insurance Division of the Department of Commerce and Consumer Affairs to one, plan and administer income tax credits relating to emergency management or disaster preparedness and grants for low-income taxpayers to fortify their residential real property. 2, oversee the development of emergency shelters, and 3, hire necessary personnel. First on our list from the Department of the Attorney General, Deputy Attorney General Stella Cam.
Good morning, chairs, vice chair, members of the committee. Stella Cam, Deputy Attorney General. We've provided suggestions and an example in our comments testimony, and I'm available for any questions if you have them.
Okay, thank you so much. Okay. Administrator James Barros, Hawai'i. Offering comments, Nadine Ando, Director, DCCA. Okay, comments. Tom Yamachika, Tax Foundation, offering comments on Zoom.
Morning, chairs, vice chairs, members of the committees. Tom Yamachika from Tax Foundation of Hawaii. We're concerned that the bill as written is too vague to be enacted into law. The bills, we're concerned primarily about the part where it authorizes the giving out of tax credits, but there are no details whatsoever about the type of taxpayers who would be eligible for the credit, under what circumstances do they need to be, do costs need to be reimbursed? Do they just have to be there, etc. So we are very concerned about the vagueness of the current version of the bill. Thank you. I'd be happy to answer any questions.
Okay, thank you, Mr. Yamachika. Jacob Winecheck in support, and Dr. Keone Dudley in support on Zoom.
Can you hear me?
Yes, we can hear you now. Please proceed, okay. Dr. Dudley.
Good, thank you. Thank you very much, Chair Keoho Kolole and Chair Elefante and members. In answer to the question about the tax credits and so forth and the vagueness of this bill, this is one of 6 bills that we have before the legislature this year for hurricane preparedness. This office is terribly, terribly important because the reason we haven't done anything for preparedness for hurricanes is because we don't have an office and we don't have any funding. There's nobody in charge of doing this. The real, FEMA is really focused on cleanup. HIEMA has been focused on cleanup. There's nobody really focused on preparing for hurricanes. And, we've got hurricanes coming, strong hurricanes. We've got to start preparing now. I ask you to look at those other 5 bills. We have a bill for grants to low-income people to start preparing their houses. We have these tax breaks for people who are more fortunate. We have the bills for strengthening existing shelters and building new ones. We have the bills for that say that houses need to be built now for hurricanes with safe rooms and bathrooms attached. I mean, the bills are there. The information is there. We need to tie these 6 bills together so that people are aware. And we desperately need to pass this bill this year. I ask you to really work on this with me and help. Thank you.
Thank you, Dr. Dudley. That completes our list of registered testifiers. Anyone else in the audience that wishes to testify on SB 696? Okay. Yes, please come forward and state your name for the record. Aloha.
So I'm Jerry Bump, Acting Insurance Commissioner. I'm not sure if you received our written testimony. I know you indicated you received testimony from the director of DCCA, but we submitted on behalf of DCCA, just offering comments, and I'm available if you have any questions.
Yes, Mr. Bump, we did get your testimony. Yeah, comments. Thank you. Is there anyone else that wishes to testify on SB 696? Okay, if not, members, questions? I'm prepared to we're preparing to roll into decision-making. So having seen some testimony and also some concerns raised from the insurance division for PSM, recommendation is to defer.
CPN, same recommendation.
Okay. Being no further business, the joint committee is adjourned.
Okay, good morning and welcome. This is our Monday. This is the Hawaii State Senate Committee on Commerce and Consumer Protection. This is the Monday, February 10th, 2025, 9:30 a.m. agenda in Conference Room 229. Conference Room 229 to hear a number of bills before the deadline. The first measure is SB 179 relating to remedies. This measure clarifies the applicability of the statute of repose for actions arising from construction defects. It clarifies the required contents of a notice claim of construction defects served on a contractor, amends the process and time frame for a claimant to accept a contractor's offer to settle or inspect and authorize the contract to proceed with repairs. It limits the amount a claimant can recover if the claimant rejects a contractor's reasonable proposal for inspection or a reasonable offer to remedy, and clarifies the consequences of rejecting an offer of settlement. First up, we have Hawaii Realtors in support.
Thank you. We stand on our testimony in support.
Thank you. Pacific Resource Partnership in support.
Chair, we stand on your testimony.
Thank you for standing on your testimony. BIA Hawaii in support. Online. Okay. DR Horton in support. Yes, please.
Thank you.
Good morning.
Good morning, Chair Kihokolole, Vice Chair Fukunaga, and members of the committee. My name is Lee Tokuhara. On behalf of DR Horton Hawaii, I am here to strongly support SB 179, which seeks to reform the Contractor Repair Act. As one of Hawaii's largest home builders, DR Horton is committed to developing multifamily units, including condos and townhomes, and production housing that maximize Oahu's limited land and offer affordable options for our working families. However, the current legal environment undermines our efforts. The dense nature of these projects makes them prime targets for class action lawsuits, from construction defect attorneys. The statistics are alarming. Before 2010, only 6 construction defect lawsuits were filed in Hawaii. Since then, that number has surged to 65. This exponential increase in litigation poses a serious threat to the future of housing development for our state. 5 recent class action lawsuits resulted in attorneys collecting nearly $50 million in fees. Some of these cases dragged on for more than 8 years, leaving both homeowners and home builders in prolonged uncertainty. And once a class action lawsuit is filed and certified, we are legally prohibited from directly communicating with the homeowners involved. This leaves homeowners unaware of their inclusion in a lawsuit and uninformed about their rights, including the option to opt out. SB 179 fosters a balanced approach that safeguards homeowners' rights while enabling builders to continue contributing to Hawaii's housing supply. The reforms ensure that legitimate defects are addressed swiftly and fairly, reducing unnecessary litigation that ultimately burdens homeowners, home builders, and the broader community. For the sake of Hawaii's working families, I respectfully urge you to pass SB 179. Thank you.
Thank you. Next, we have Kasdan Turner Thompson Booth LLC in opposition. Good morning.
Good morning. Hi, Chair, Vice Chair, members of the committee. My name is Chris Akita. I'm a partner at Kasdan Turner Thompson Booth. We represent homeowners and associations to recover construction defects. I'm submitting my testimony in opposition of SB 179. I just want to highlight the key, ideas in my written testimony. This bill does not achieve the committee's goals of creating more affordable housing. What it does is it ignores the hidden costs of housing, which are construction defects, and makes home ownership more unaffordable by making it difficult or impossible for homeowners to recover for construction defects. It shifts the cost of repairing those defects to the consumer. Homeowners would not only be required to responsible for paying for the high cost of housing, but would also be responsible for repairing the developer's mistakes. There are numerous significant problems with SB 179. It essentially reads as a wish list for developers, providing them with significant ammunition to avoid liability for their construction defects. But the main thing is this purpose. The bill would ultimately prevent homeowners from pursuing legitimate claims for construction defects, and it would also weaponize the Contractor Repair Act. There's various, I attack each one individually, and I'm happy to answer any questions you have on each of the provisions in the bill. But ultimately, the Contractor Repair Act already allows for abuse by developers and contractors as a one-way process. It only requires information to flow in one direction. And it also contains no time constraints, meaning that this process can go on forever. Developers and contractors currently use the statute to significantly delay the process, leading to a purgatory, which significantly delays resolution. This bill will ultimately allow developers to further weaponize the process, leading to significantly delayed and insufficient resolution. And ultimately, SB 179 would make homeownership more costly for people in Hawaii and lead to Hawaii being one of the least consumer-friendly states for homeowners. Thank you.
Thank you. Holomua Collaborative in support.
We'll stand on our testimony in support, Chair. Thank you very much.
Thank you for standing on your testimony. Lipsmith LLP in opposition.
Good morning, Chair, Vice Chair, and committee members. Thank you for the opportunity to testify on SB 179. We strongly urge the Senate to reject SB 179 because it's going to endanger the homeowners in Hawaii, and it defeats the Contractor Repair Act's core goals. Lawyers in our firm have spent the last 15 years representing Hawaii homeowners in class actions, where our goal is to get repairs for rusting structural components. We so far have achieved repairs on more than 4,000 homes in Hawaii. If enacted, SB 179 would defeat the Contractor Repair Act's original purposes of speedy, precise, and inexpensive resolution of construction claims. First, SB 179 will upend purchase agreements and warranties already in place for homes built over the last 2 decades. The purchaser agreements and warranties that the builders and purchasers of homes get into are very complex documents. This bill is not about clarifying the current statute of repose or the Contractor Right of Repair Act. It's about rewriting them in ways to undermine consumer rights and protections. This, if enacted, SB 179 will reduce the periods for homeowners to bring warranty claims and warranties that our clients already have. Many of these warranties are 10 years. The builders seek to reduce those warranty periods by imposing new timelines for people to bring claims. This will also change the notice requirements, dispute resolution provisions, and remedies available in the current contracts that have been enacted for the last 21 years across Hawaii since the last CRA was adopted. Also allowing inspections on all homes and class actions will grind litigation to a halt. We're in 2 cases right now where the builder is asked to inspect every single class home, and this process is now taking years, not the period of days that the Contractor Repair Act currently envisions. I'm here to answer any questions should you have any, but we urge that the Senate reject SB 179. Thank you.
Thank you, Philip Nerney, in opposition.
Chair, Vice Chair, committee members, I only want to emphasize that what I'm hearing from the 2 sides suggests that greater alternative dispute resolution mechanism should be the focus of the Senate's attention. Thank you.
Thank you very much. Patricia Van Curren in support.
Yes,
Morning.
hi, good morning. My name is Patty Van Kuren. I work at First Hawaiian Bank and I've been in mortgage for 20 years. And I stand on my testimony and just want to say my personal experience has been that a lot of people have limited access to mortgage lending when the class actions are placed broadly against the buildings. And I've seen the expense be passed along to the client in higher rates and fewer loan products, especially to our lower income citizens. Thank you.
Thank you very much. Hawaii Regional Council of Carpenters in support. Good morning.
Good morning. Here we go. Good morning, Chair, Vice Chair, members of the committee. My name is Mitchell Tainanis. I'm a field representative with the Hawaii Regional Council of Carpenters. We represent thousands of carpenters in Hawaii, men, women who build homes that families rely on and take great pride in their work. I stand by my written testimony, but I want to emphasize on 3 main points. Lawsuits are stopping projects from homes that aren't even built, leaving skilled carpenters out of work. When developers get sued, projects stop, and our members lose work. Some attorneys are exploiting the systems, targeting materials and methods that are fully up to code. In some cases, aggressive attorneys exploit systems by targeting material and construction methods that are fully approved under the county building codes. We support fixing legitimate defects, but the current abuse is delaying homes, driving up costs, and hurting workers. We need reforms to stop lawsuit abuse, keep projects moving, and allow builders and homeowners to work together before heading to court. The Hawaii Regional Council of Carpenters stands ready to work with lawmakers and stakeholders to advance policies that promote housing affordability, job sustainability, and a thriving construction industry. Mahalo for your time and your consideration.
Thank you. That's all the registered testimony we've received on this measure. I'd like to note that in terms of written testimony, there were 105 individuals and organizations who submitted written testimony in support of this measure. 4 in opposition, including the testifiers who presented today. And 1 organization provided testimony with comments. Is there anyone else who would like to testify on this measure? Members, questions? Vice Chair.
I'd like to ask Mr. Nerney to elaborate a little bit on his recommendations for alternative dispute resolution.
Thank you, Senator. And the Senator might not be surprised that I am thinking that something more aligned with early neutral evaluation would be appropriate. So right now, under the Contractor Repair Act, you've got mediation, but it isn't a very structured process. I haven't done construction defect work for a very long time. What I did when I did it was to get a particular mediator who's very skilled. And that mediator uses, at least historically, has used an expert roundtable process. And with that process, you take the experts out of the advocacy component, and you just convene and find out, is there a problem? As an architect, you got a bunch of architects. Is there or is there not an architectural issue? Forget who's at fault, forget what you do about it. If there is a problem, then you start looking at, well, what's the gold-plated fix? What's the average fix? You know, what's the minimally acceptable fix? And you go through that process seriatim. And then you reduce that product to something lawyers might argue about. But I think greater opportunities for people to just evaluate whether there is or is not a problem is appropriate, and there are mechanisms in place that would assist that.
Are you familiar with the Judiciary's Alternative Dispute Resolution Center?
Yes.
Are those types of forums among the types of forums you envision being an initial, I guess, mechanism for this type of assistance?
I frankly anticipate that people would go to private places, AAA, DPR, something along that line. Of course, courts can manage their own dockets and order parties. I just think that the deficiency is in the structure of the process and the antagonism that the parties naturally have towards one another.
Okay, thank you.
Members, any other questions? Okay, we'll move on to the next measure, SB 416, relating to the Residential Landlord Tenant Code. This measure prohibits rental agreements from prohibiting tenants from keeping pet animals in dwelling units subject to certain conditions. Let me see, Hawaii Realtors with comments?
Thank you, stand on our comments.
Thank you. Attorney General's Office with comments.
Good morning, Deputy Attorney General Christopher Hahn with comments on the bill. The way this bill is written could affect existing contracts, so we've recommended inserting a non-impairment savings clause. Thank you.
Thank you. That's all the registered testimony we've received. In terms of written testimony, we have Heather McVeigh in support, Victor Brock in opposition, and Ann Pincaithley in support. Is there anyone else who would like to testify? Members, questions? Moving on, the next measure is SB 593 relating to commercial dog breeders. This measure defines a dog breeder as any person who owns, possesses, controls, or otherwise has charge or custody of more than 10 dogs over the age of 12 months with intact sexual organs, and who sells, barters, or otherwise transfers more than 3 litters or more than 25 dogs per calendar year. It requires dog breeders to meet minimum standards of care and not place certain types of dogs in the same enclosure to ensure the proper treatment and care of dogs and the dog's offspring. It prohibits a person from owning or having custody of more than 30 dogs over 1 year with intact sexual organs, and requires dog breeders to maintain specific written records for each dog for a specified period. It also authorizes each county to assess, implement, and enforce its own licensing system, and establishes civil and criminal penalties for violations. Let me see. The only registered testifier we have is the Hawaii Humane Society in support. Good morning.
Chair, Steph Kendrick from the Hawaiian Humane Society in support of this measure. We're in strong support of regulating pet animal breeding, and this bill would be a great step in that direction. Hawaii's one of very few states that don't regulate this industry at all. I would, though, point out that this bill creates a statewide regulatory regime, but expects the counties to enforce it without any funding. So we would humbly suggest that some funding is added to this measure for enforcement. I'm happy to answer any questions. Thank you.
Thank you. We also have, is there anyone else who would like to testify? Okay, the American Kennel Club submitted written testimony with comments, Animal Rights Hawaii in support, Aloha Animal Advocates in support, Suyin Freiberg in support, Clayton Cotton in opposition, Lorraine Maki, opposition, Terry Ni'i, opposition, Bobby Becker in support, and late testimony from the Pacific Pet Alliance with comments. Members, questions? Senator Richards.
Yeah, Humane Society, please.
Aloha, Senator.
Good morning. You made a comment that you support this for pet animals, which you excluded working animals, or do you categorize them the same?
Dogs are all defined as pet animals under our statute, so we would consider any dog breeding to be pet animal breeding, even if they will be working animals.
Okay. All right, I can see where there could be a conflict with some of the agriculture. Okay, thank you, Chair.
Members, any other questions? Okay, thank you very much. Moving on. The next measure is SB 641 relating to alcohol. This measure defines low alcohol by volume spirits beverage, establishes a tax on low alcohol by volume spirits beverages at a rate of 85 cents per wine gallon. Department of Taxation with comments.
The Piper Department of Taxation stand on the written comments.
Thank you for standing on your testimony. Tax Foundation with comments.
Not available on Zoom, Chair.
Thank you. Wine Institute in opposition.
Also not available on Zoom, Chair.
Thank you.
Sorry.
Sorry, I am here. Good morning, Chair, Vice Chair, members of the committee, Mihoko Ito on behalf of the Wine Institute. We are respectfully opposed to this measure. And the reason is this. This is giving one category of tax, alcohol taxes, just one class, its own criteria and giving them a tax break. So it's fundamentally changing the tax structure, which is right now a gallonage tax, and establishing a separate category, alcohol by volume, just for this one segment of the industry. And it is the fastest growing segment of the industry. So it does represent a tax break. We believe it'll result in a revenue loss for the state that's been documented by the experience of the few other states that have passed it. Happy to answer any questions. Thank you.
Thank you. Is there anyone else who would like to testify? Okay, we also have written testimony and support from the Pali Brewing Company, the Beer Institute with comments, Paula Hagel in support, and Jane Kearns in support. Members, questions? Vice Chair?
For Wine Institute, you had a chart in your testimony and cited revenue losses for other states.
Yes.
Do you have additional information?
I'd be happy to follow up and provide you the underlying study. I'm happy
Okay.
to email that to the committee.
Okay, thank you.
Thank you.
Any other questions? Okay, moving on, SB 1048 relating to solicitation of funds from the public. This measure amends Act 205 of last year to clarify safeguards and standards in online crowdfunding. Attorney General's office with comments.
Good morning, Chair, Vice Chair, members of the committee. Christy Chang, appearing on behalf of the Department of the Attorney General. We provided comments to this bill and are available for any questions. And thank you for the opportunity to testify.
Thank you. GoFundMe in support online.
Good morning. I'm Margaret Richardson, Chief Corporate Affairs Officer at GoFundMe, and thank you for the opportunity to testify. GoFundMe strongly supports SB 1048, which protects the philanthropic space from misuse while reducing unnecessary burdens. We're a trusted leader in online fundraising, having helped raise and distribute more than $30 billion to individuals and nonprofits worldwide. Following the Lahaina wildfires in August of 2023, over $65 million was raised on GoFundMe to support both individuals and nonprofit. And while well-intended, Act 205 creates significant challenges for charitable fundraising in Hawaii. If left unchanged, it will slow down donations, create administrative burdens on nonprofits, and limit critical support, especially in times of crisis where time is of the essence. Similar issues in California's AB 488 have caused confusion, barriers for nonprofits, and SB 1048 offers common sense fixes to prevent the same challenges in Hawaii. Some areas of concern addressed in SB 1048 include the registration, 10-day waiting period, and bonding requirements, ensuring due process requirements for good standing provisions, utilizing data minimization best practices related to donor information retention, eliminating burdensome new requirements, and finally, offering the Department of Justice discretion, giving the Office of the Attorney General the authority to waive requirements if it deems the operations of the platform to meet the goals of this bill, and delaying the effective date to allow time for effective implementation and stakeholder engagement. We also support the parts of SB 1311. We support parts of SB 1311, but believe it falls short in critical areas. We look forward to working with the Office of the Attorney General in our future meetings, and we are very grateful for the opportunity to provide feedback here and look forward to any questions.
Thank you. Is there anyone else who'd like to testify? Members, any questions? Okay, we'll move on. SB 1213 relating to electronic service of process allows businesses in the state to designate an email address to accept service of process in lieu of continuously maintaining a registered agent in the state. DCCA BREG with comments. Good morning.
Good morning, Chair, Vice Chair, members of the committee. My name is Rainy Nakamura Watanabe, and I'm here testifying on behalf of the Department of Commerce and Consumer Affairs Business Registration Division. We stand on our written testimony, offering comments on this bill. Thank you for the opportunity.
Thank you. LegalZoom in opposition. Good morning.
Thank you. Good morning. My name is Allison DeSantis, and I'm an attorney at LegalZoom. We have helped our customers form over 4 million businesses in the United States, serving as registered agent for many of those entities. We currently serve for the registered agent of about 4,500 active entities in Hawaii. I joined LegalZoom last year after spending about 16 years with the Ohio Secretary of State's office as the Director of Business Services and Assistant Secretary of State. With my background, I have a deep understanding of the critical role of registered agents and how they play an important part in connecting government offices to the business entities. Our concern is that email does not offer the same level of reliability as in-person delivery or certified mail. Service of process is a fundamental step in our legal procedures, ensuring individuals and businesses are notified of legal actions against them. Emails can be lost in spam filters, overlooked by recipients, caught up in technical failures, or even worse, intercepted and altered by bad actors. Allowing service of process by email also opens up the avenue for phishing attacks. If an email address is used as the registered agent, then business owners may be forced to open every incoming email, even suspicious ones. We've seen phishers attacking individuals and businesses. This can lead to data breaches, financial loss, and disruption to the operation of their business. I urge you to reconsider this proposed legislation, as service of process is a fundamental part of due process, ensuring each defendant has an opportunity to be heard. Thank you for your time and your consideration.
Thank you. Honolulu Information Service in opposition.
I'm Joe Clyburn for Honolulu Information Service. We locally provide the registered agent services and are part of a national association, and I totally agree with the points.
Our recording of the proceeding cannot catch your statements unless you're on the record.
To restate, I'm Joe Clyburn with Honolulu Information Service, and I totally agree with the points described by LegalZoom's representation and stand by our testimony as well. And just from a personal perspective, in our company, we're a small company compared to some of these large entities. We have to call and follow up, even though we have specific instructions from our clients on how to handle documents that are served for them, service of process. And that personal service and follow through makes all the difference for them and the legal process and moving forward. Otherwise, it can be complicated and create more problems going forward. So I'm here to answer any questions if you prefer. Otherwise, thank you very much for this.
Thank you.
Thank you.
Is there anyone else who would like to testify? We have written testimony from one organization, the NPRRA, in opposition. Members' questions? Okay, if not, we'll move to the last measure on this agenda, SB 1563, relating to insurance. This measure establishes rate transparency requirements for insurance companies operating in the state, establishes and appropriates monies for an Office of Insurance Consumer Affairs within the Insurance Division of the DCCA to provide oversight, information, and consumer advocacy. DCCA with comments.
Good morning, Chair, Vice Chair, members of the committee. Jerry Von Packing, Insurance Commissioner. We'll stand on our written testimony providing comments.
Thank you for standing on your testimony. Hawai'i Insurers Council in opposition.
We'll stand on our testimony in opposition.
Thank you. NAMIC in opposition. AARP in support. That's all the testimony we've received. Is there anyone else who would like to testify? Members, any questions? Okay, recess. Okay, we are back on this Monday, February 10th, 2025, 9:35 a.m. hearing in conference room 229. This is the Senate CPN Committee for Decision Making on the agenda previously heard. The first measure is SB 179 relating to remedies. The recommendation on this measure is to pass with amendments. There are some technical, non-substantive amendments, and we will defect the effective date of this measure to July 1, 2050. Any discussion? Vice Chair.
I will be voting with reservations on this. I have some concerns about the 2-year limitation.
So noted. Any other comments or questions? If not, Vice Chair for the vote. Chair votes aye.
Thank you. Vice Chair votes with reservations. Senator McKelvey? Yes. Senator Richards?
Aye.
Senator Awa?
No.
Your measure is adopted.
Thank you very much. The next measure is SB 416 relating to the Residential Landlord Tenant Code. The recommendation is to pass this measure with amendments. Will defect the effective date to July 1, 2050 to further discussion.
Chair.
Any, Senator Richards.
Yeah, I have some concerns. I'll be voting with reservations on this one.
So noted. Any other comments or questions? Seeing none, passing with amendments. Chair votes aye.
Thank you. Vice Chair also votes aye. Senator McKelvey?
Yes.
Senator Richards?
Reservations?
Senator Awa?
No.
Your measure is adopted.
Thank you. Next measure is SB 593 relating to commercial dog breeders. The recommendation on this measure is to pass with amendments. We will adopt the language proposed by the American Kennel Club, changing the or to the and, as noted in the testimony. We'll also defect the effective date of this measure to July 1, 2050. Any discussion?
Chair.
Senator Richards.
Yeah, thank you. I raised a little bit during testimony. I completely agree that we need to neuter more animals and cut down the population. But there are some working dog breeders that do a good job, and this could have an impact on them. So I'm going with reservations on this.
So noted. Any other questions or comments? Okay, seeing none, Vice Chair passing with amendments. Chair votes aye.
Thank you. Vice Chair also votes aye. Senator McKelvey?
Yes.
Senator Richards?
Reservations?
Senator Awa?
No.
Thank you. Your measure is adopted.
Thank you. The next measure is SB 641 relating to alcohol. The recommendation on this measure is to pass with amendments. We will defect the effective date of this measure to July 1, 2050. Any discussion? Vice Chair.
We'll be voting with reservations.
So noted. Any other comments or questions? Okay, if not, Vice Chair passing with amendments. Chair votes aye.
Thank you. Vice Chair votes with reservation. Senator McKelvey?
Yes.
Senator Richards?
Yes.
Senator Awa?
No.
Thank you. Your measure is adopted.
Thank you very much. The next measure is SB 1048, relating to solicitation of funds from the public. The recommendation on this measure is to pass with amendments, adopting the Attorney General's proposed amendments, making some technical, non-substantive changes, and defecting the effective date of this measure to July 1, 2050. Any discussion? Okay, seeing none, Vice Chair passing with amendments, Chair votes aye.
Thank you. Vice Chair also votes aye. Senator McKelvey?
Yes.
Senator Richards?
Aye.
Senator Awa?
Aye.
Your measure is adopted.
Thank you. The next measure is SB 1213, relating to electronic service of process. Seeing as no one likes this bill, we'll defer it. The last measure is SB 1563, relating to insurance. The recommendation on this measure is to pass with amendments, defecting the effective date of the measure to July 1, 2050, to further discuss this measure. Any comments or questions? Okay, seeing none, Vice Chair passing with amendments, Chair votes aye.
Thank you. Of the CPN members present, are there any voting with reservations or objections? Hearing none, measure is adopted.
Thank you, we're adjourned.